Let's talk about mediation. Mediation is a process where you have an independent third party as a go-between the parties to a divorce. Mediation can be preferable for many reasons. Generally, it's a good way to speak your side of the story and be in control of what happens. Before you go to trial in Washington State, mediation is required. Most of the times, divorce matters, child custody matters, they settle during the mediation process. Mediation is also preferable because it can be much less expensive than full-blown litigation. How does mediation work? Well, the independent third party, who is generally an attorney, will go in between the two separate rooms where the parties are located. He'll listen to both sides, and what he will do is he will tell you what is likely to happen if this matter goes to trial. They are very instrumental in letting each side know their strengths and their weaknesses. Once the parties understand what their strengths and weaknesses are, they're much more liable to end up coming to a resolution short of having to go to trial. So what is litigation? Litigation is the process you go through that usually ends up in a trial on the issues. It's different from mediation because in mediation, you have control of what's going on when you work with an independent third party who goes between the two parties to try to come to a resolution. If mediation fails, or if you just decide you don't want to do mediation and you can't resolve it prior to trial, then you will have to go through that process. Mediation is preferable because it's much less expensive, and you have control over what happens. If you have to go to trial, you have to pay all the trial costs, and at the end of the day, a judge is going to determine how your assets are divided and what happens to your children. Although you can't put an exact number on it, what I can tell you from my own experience and the experience of my law firm, mediation is much less expensive. And the reason for that is if you cannot come to an agreement during the mediation, then you're likely going to go through motion practice, hearings, and ultimately a trial. If you can resolve your case at mediation, you don't have to take those additional steps, which saves on a ton of expense. So when might mediation not be an option? Well, in a couple of situations. Probably the most common is the other side just flat refuses to show up for mediation. What they'll have is they'll have it scheduled, you'll have to attend it, but if the other party doesn't show up, the mediation can occur. You cannot force somebody to go somewhere they don't want to be. Another limited situation if there might be domestic violence issues. If there's domestic violence issues, perhaps a court will not require a mediation before a trial. Before you go to trial in Washington State, mediation is required. Sometimes, in very complex situations where the parties absolutely cannot come to an agreement on all their issues, mediation may not be successful and trial will be required. If you have any further questions regarding the differences between mediation, litigation, please give us a call. At Johnson Law Firm, we fight for families and their fresh start.